Hello, my name is Professor Brett Davies. I'm a barrister and solicitor at Legal Consolidated. Well, I've just come out of a rather difficult audit from the ATO of our client's Division 7A loan agreement. And I think that it is a timely reminder that if you are not squeaky clean with your regulator, then they will look for other ways to get at you. So I strongly recommend that all your paperwork's up to date. In this instance, the Division 7A was not up to date, was not as it should be. It wasn't commercial. Let's have a look at Division 7A. So we have a company, and the company pays tax at a constant rate of, let's say, 30%. Whereas mum and dad, at their highest marginal tax rate, may pay tax at, say, almost 50 cents on the dollar. Let's say 49%. So there's a big difference between 30% and 49%. So what you do is you have your company absorb the income, maybe it's distributions from a family trust, an unpaid present entitlement most commonly, and let the company pay tax at 30%. And then what you do is you go into your company, because it's your company, and you borrow the money, take the money, do whatever you want to do. You buy your boat, you pay your school fees, and you live your life. That is no longer possible, if it was possible at all, because Division 7A has been inserted into the Income Tax Assessment Act, so that now, if you do take money out of the company, let's say not by way of a dividend, then you will suffer the consequence of Division 7A unless you have a commercial loan agreement, which your accountant, advisor and lawyer has nicknamed as Division 7A loan agreements. Well, if you have a Div 7A loan agreement, it should be okay. Not necessarily. Firstly, a commercial loan would be normally drafted by way of deed, D-E-E-D, by way of deed, not by way of agreement. Because that's such an important document, you should sign it under seal, as a deed. If you sign as an agreement, it may not be commercially valid and may not be valid as a contract as well, because a contract requires 7 conditions, and one of them is consideration, passing of money, both backwards and forwards. Well, a loan agreement has people paying money back, so maybe that's sufficient consideration, but often it's the case that no money changes hands. The payment of the Div 7A at the end of the year of interest and what have you may be done by way of dividend or by journal entries. It may not be done with real cash, and a journal entry may not be sufficient to warrant the level of consideration, and therefore your loan agreement may not be valid. Your Division 7A loan agreement may not be valid. In which case, you're lending yourself to be liable to the ATO if they're trying to attack you. Now, the second problem that we've identified is that there are a number of references to Div 7As that we reviewed to an out-of-date practice statement, and that out-of-date practice statement is PSLA 2007-20. Well, it's no longer the ATO's position on that. It's wrong. The ATO has withdrawn that practice statement, and yet there's Division 7As that are referring to it, and therefore that contaminates the integrity of the agreement. The next thing people are doing is referring to Section 109E5 of the Income Tax Assessment Act, which is fine. That section of the Act is still compliant. But if the laws change, and they seem to do all the time, then you've got a problem. Unless you put into your deed to say that if one Act is changed and a new Act comes in and that now replaces the old Act, the old sections of the Act, but the Division 7A loan agreements we've been seeing are not drafted that way, and therefore there's contamination if the laws change. Finally, and I have to agree with a regulator that attacks the Div 7A on this basis, finally, your loan agreement should have an acceleration clause. Now basically what that is that if you merrily pay your interest on the loan and the capital, all good, no problems at all. But if you default on the loan, then the lender, whether it be the bank or in your case the company, the company can accelerate all capital and all interest that is owing under the Div 7A, under the loan agreement, accelerate it all so you have to pay it right now today. Now sure, you don't do that between interrelated parties because your company and your shareholders are generally friends. But that's not commercial. It's commercial to have an acceleration clause in your loan agreement. There should have been one there. Now what I recommend you do is get out your Div 7A loan agreement, show it to your accountant, and if you want, you're welcome to see at no charge the legal consolidated sample document on our website. It's even got explanatory memorandum all the way through it to help you in these sort of situations. And if you need to, go back to your solicitor or go onto our website and generate yourself a fully compliant Division 7A loan deed. If you need help, you can telephone us because we're a law firm and we can give legal advice. And that's the advantage of using a law firm. Enjoy that benefit.